Aloha, welcome to the Triple F Show. I'm Jim Hochberg, and we're going to talk today. Hope you stick around. Eva and I are going to talk about a huge collision that's happening right now between the federal government's role, between the administrative state, between religious liberty on the topic of abortion. And we're going to actually start in 1991 in Hawaii. So, Eva, shall we chat?
Let's chat about that.
So, Eva, we're talking about the administrative state, the boogeyman that the founding fathers never wanted in the federal government.
I was thinking as we were preparing for this show that you've over the years had many a pet peeve. And I thought it's really interesting that as we move into these last two shows that you're doing, that we would do a show on an intersection of two of your pet peeves when it comes to the way our government does business. So let it roll, Jim. I mean, I think people need to know that this is going to be a firecracker show for sure.
Well, and it's not an intersection like a paved road. What are those things called where it's on a wooden frame and then strings hang down with heavy balls and they bang each other?
Oh, yeah, that one of those.
It's more like that.
Yeah. Okay.
So I want to start to put it in context.
I was thinking of those slippers that local people wear that have the little pokey stuffs on there to like massage your feet when you walk.
Oh, I hate those.
They hurt like yes.
Yeah, that's
so
not
it's
for
kind
me.
of like that to me. That's so okay.
So as Pastor Waxer at One Love Ministries, one of the Calvary chapels here that my wife and I go to from time to time, almost all the time, always says that content plus context equals meaning. And it's if you just ponder that, it's really true.
So what are the three things? Because I know that the way we're doing the show now is to talk about, to put this into nice compartmentalized
So the
topics.
first thing we're going to do is context.
Okay.
The second thing we're going to do is talk about the collision. And the third thing we're going to do is talk about what happened after the collision. And it's a court case.
Oh, the 3 C's.
Yes, ma'am.
Okay.
Because I went to the Alan Cardenas School of Public Speaking.
That's right. And once you get a good talking point, man, stick with it and say it 52 times.
So I want to go back to 1991 in the Hawaii State Legislature.
And Rachel, my daughter Rachel, was born. It was a great year.
And we were testifying against a proposed change in the employment discrimination law in Hawaii. And the change that was being proposed was to add as a protected class, and at that time, the classes were race, religion, national origin, sex, which meant being male or female. Maybe there was something else like arrest and court record or something, that the anti-discrimination and employment law would say employers can't discriminate against prospective employees, current employees, or ex-employees on the grounds of any of those protected classes. They wanted to add to the list sexual orientation. And this was back when the supporters of putting sexual orientation as a protected class testified right at the legislature, 1991. We don't want anything. We don't want same-sex marriage. We don't want nothing except we want to be able to keep our jobs. Remember that?
Visit people in the hospital, or was that
this
moved
is
later?
only employment. This was only employment related.
We've had many a time when
Correct.
we were.
This is 1991.
Yes. Okay, so we're going back. Yes.
So I testified against the measure at the legislature on behalf of religious employees, religious employers, churches, and religious organizations. And the reason was the employment anti-discrimination laws say you can't do certain things on the basis of these protected classes. One of them, you can't fail to hire. Two, you can't treat hired employees different in the terms and conditions of employment based on those. Three, you can't fire people based on that. And those are kind of the three that everybody thinks about. But you also can't have published material or spoken or recorded material that is discriminatory. And so when sexual orientation was being put into the employment anti-discrimination law, one of the arguments was, look, that's a religious issue. And if a construction worker that works for a company happens to be religious and he happens to wear a t-shirt with some words on it that make a gay coworker feel discriminated against, the employer is punished for it.
You know what?
Or if the employer is a religious employer that has the Bible in it, they have to take the Bible out of the church.
Okay, I was working, I was not doing all the political stuff back in 1991. I was working for a very big organization at the time in accounting. And I remember, I'm not going to say the name because I don't want to get in trouble, but we knew that all this stuff was coming down the pike because we had a small group of people that I still keep in contact with today. We were all Christians, and we would meet for Bible study and pray and stuff like that. And do you know that what happened at December of, I think it was 1990, December of 1990, or it might have been December of 1991, but it was around that time period. They decided to change the name of the Christmas party to holiday party because people were offended by that. So that was a big thing going around at the time.
So I testified that they should not pass the bill because it would violate all these different perspective groups of people, and I would have to sue them. Well, they passed the bill. So I put together with the Rutherford Institute in 1991, this was pre-ADF, a federal lawsuit challenging that new edition of sexual orientation on behalf of an association of religious organizations, institutions, and persons. So I had church clients, employee clients. In fact, one of my high school buddies was I forget what trade he was in, but he was a tradesman, and he loved to wear religious t-shirts all the time because it would strike up conversations with people in the house or whatever. I think he was a painter. And so I filed this lawsuit, and in response to the lawsuit, it was very interesting because at the legislative hearing, the AGs were in favor of this, as you would expect.
I was going to say,
when I filed my lawsuit, they answered the lawsuit with a motion to dismiss because the state of Hawaii would never enforce this law the way the plaintiffs are suggesting.
Say that again? That again?
Would never enforce this law the way the plaintiffs are suggesting. So there's no real claim. So I had Judge Alan Kay as my judge in the U.S. District Court. And so he took their position. He said, okay, state of Hawaii, I am going to write an order dismissing this case based on your 10 statements that you are never going to enforce it this way. So I actually had, subsequent to that, other employer law firm friends calling me saying, hey, can I get a copy of that order? So I was called anyway. So that's the context, because what we're going to talk about in the next section is a new version of the same thing in 2024 at the congressional and the administrative state level.
So at the risk of beating a dead horse, you and I do this every time we do a show. This is why when there's a bad law or a good law, you have to keep paying attention because it doesn't ever stop, right? The discussions never stop. People always want more.
Correct.
Or they want to clarify something. So, yeah. So
let's get into the second.
Let's get into it.
So
yes.
Under the jurisdiction in the Constitution of the United States of the executive branch, which the president is in charge of, vice president is under him, and then the secretary of all the departments, and then the deputies under all of them, and all the way down to the federal building in Honolulu that has our U.S. district jurisdiction offices of all those same administrative agencies. So we don't vote for anybody but the president and the vice president. They nominate the secretaries of the departments, Senate confirms, but all the rest of them down below are civil service employees or appointed people, whatever. So in order for Congress to make a new law, which is what happened, a lot of times, most of the time now, since FDR was president, they put in there that the agency, the department that this law falls under, will make rules and regulations to explain how it works and how to punish for violating and stuff. And so under the law, if the agency does something that's outside the scope of what the statute from Congress said they're supposed to do, they can't do it. But under recent presidents, they say, go ahead and do it anyway. And if we lose in court, at least we won for the time it was working, right? So that's what this case is about. You want to introduce the law that we're talking about?
We are talking about a law that was recently passed it was a bipartisan.
In 2022.
In 2022. It was called the Pregnant Women Fairness Act.
No, it's not. It's the Pregnant Worker.
Oh, I'm sorry.
It makes a difference because men are included.
I'm sorry.
Now.
I'm always like hyper focused that women get pregnant. But yes, you're right. Sorry. Pregnant Workers Fairness Act. And it actually was a very good act. And it was going to make sure that pregnant women were not discriminated against.
It was
in the
very
workplace.
pro-life.
It was
bill.
pro-life. Both Democrats and Republicans made floor speeches saying, this is a good thing. Here's what it does. Here's the way we're going to protect pregnant women. It does not include abortion.
Why was that necessary to be said?
Well,
what was the phrase that people were talking about?
I'm not sure what phrase you're referring to, but I will tell you that in order for them to get bipartisan support, they wanted to make sure that they stayed away from this controversial thing, because none of the Republicans, or most of the Republicans, would not have signed on to it had they included abortion. And even though that the Democrats might have supported it, there are a few pro-life Democrats that would not have supported it. Mm-hmm. So I think they wanted a really good piece of legislation that was going to do what the title said it was going to do, which is to protect pregnant women.
So the reason that phrase is important, the phrase is pregnancy, childbirth, or related medical conditions. That's what is being protected. Pregnancy, childbirth, or related medical conditions. And
pregnancy. So
correct. So the testimony or the speeches in Congress were, this does not include abortion because abortion is not medical condition related to pregnancy or childbirth,
right?
Because it ends, right?
And that's what caused a lot of the confusion as we start moving, into, I know we're not there yet, but when we get into the last part of the show, when we talk about what's happening, the causation now of what the EEOC's rules have done, because it's confusing now, because when a woman chooses to have an abortion, she's terminating a pregnancy.
And they call that reproductive freedom.
Whatever they call it.
Is what they call it, but
right.
It's not health care.
It's right. So Congress passes this bipartisan act, and everybody was excited about it.
And
It
said EEOC, which is the enforcement mechanism for anti-discrimination in employment, that's the department. Mm-hmm. You go make some rules. So they went and make some rules, and it came out in April.
And knowing about the rules, many organizations, including the Alliance Defending Freedom, the United States Conference of Catholic Bishops, many organizations wrote saying, do not include, because they kind of knew, they saw the writing on the wall. They kind of knew what, and EEOC also is known for this, right? We've done another show about their rulemaking and all the craziness that goes into there. So, you had people reaching out saying, don't include this. And there were 54,000 comments opposing adding abortion to this.
And there were 40,000 supporting adding abortion. And in the explanation of the process to come up with the rules, the EEOC said, so that's a wash.
Well, either that or they said, we'll ignore the 54,000 and just assume that everybody wants to do this.
Yeah. So I kind of think the Democrats went along with this in the congressional action because they already knew they controlled the EEOC, so they were going to change it into an abortion protection thing. But the weirdest part about it is it includes things like lactation is one of the pregnancy-related things. If you're having lactation problems after childbirth, you can't be discriminated against if you have to go to the hospital. The whole thing was, okay, employers, if you have 15 or more employees, this applies to you. You can't treat your employees bad if they're pregnant, if they give childbirth, if after childbirth they have lactation problems and all this kind of stuff, because we're protecting them as this is the new protected class under the anti-discrimination. Well, what do you think those guys that take the hormones so they can give milk? That's lactation.
Well, and that becomes part. I mean, this thing is convoluted now. When you start adding that,
Well,
in
the
there,
regulations
it could mean
are only
anything.
844 pages long.
Yeah, and you know what? I remember at the time there was a lot of groups that were encouraging people to submit comments. You know, I don't understand. This was so good. Correct me if I'm wrong, but does it not seem today in politics everything ends up back on the doorstep of abortion rights? Everything.
Well, this came after Dobbs.
No, well,
See,
I know that.
So
I know that.
Dobbs is like a light bulb to a night insect for pro-abortion people. They can't let it go. They have to fly into it because they lost.
So it's really interesting when we start really getting into the ramifications of the EEOC doing this. I did notice that the act itself, so the act that was passed bipartisan, contains the word abortion how many times?
I don't remember.
0. It's not in there at all.
Because it wasn't supposed to.
Right, because it wasn't in there. But the EEOC, when they came up their rules, it's mentioned 348 times.
And so the point is, the question to ask is, does this rulemaking deviate so much from the statutory direction that was given by Congress that it's invalid? And how do you find that out? You sue.
And it is interesting that...
So for the third section, we're going to come back and talk about the lawsuit that got filed.
Which is really good but I want to say that the EEOC, when they decided on these rules, did you know that it was just a 3-2 vote?
Well, that's the thing. Who are the EEOC commissioners? They're appointed by presidents in revolving terms. So when Donald Trump was the president, maybe there was 1 open seat, or maybe there were 3 open seats.
Right,
and then when Biden became president, maybe there were 2 or 1 or 3. So you get this blend of Republican and Democrat. I can't even say liberal and conservative. They're party appointed people. And this was 3-2. So it was a 5-4 Supreme Court decision.
Now,
it wasn't a Supreme Court decision. It was like a 5-4. It's a 3-2.
Now, why we're talking about this, Jim, and it's an area that is very near and dear to your heart, is because when EEOC creates rules like this, right, and the final rules have been completed, so they're not in the discussion anymore.
They go into effect 60 days after April, whatever it was, 18th, or
right?
So in June.
And the reason that we're concerned about this, you in particular, because of your background, is because of how this is going to affect faith-based organizations. This is not one of those rules that, well, there might be people that are saying, no, you can't force religious institutions to act contrary to their religious tenets. But what we're going to talk about in this last segment is how that is not the case with these particular rules.
Right. So to wrap it up from part 1 and part 2, we know that these non-discrimination and employment cases are really tricky when you start putting moral issues into them because of the free speech and the conduct and the association infringements that happen in the workplace. And when the topics are your race, your religion, your national origin, those kind of things, it's not a moral issue like abortion, gay things, physician-assisted suicide, capital punishment, homelessness. Those have big moral wraparounds, right?
Right.
So basically the EEOC thumbed its nose at Congress and made it an abortion thing. Why? Because of who's in charge of the executive branch.
And the fact that they ignored 54,000 comments in opposition. Right. And these aren't just mom and pops that are submitting these oppositions. You had some top organizations, faith-based organizations that were submitting comments saying that if they read the rules the way that EEOC wrote them. So this isn't like, well, it might mean this. They were very clear in the rulemaking what things were. And so people were horrified that these were the rules they were going to pass. And they ignore it and they pass it. So the rules are now in existence. So where do we go from here?
So it's interesting. The rules became effective, what was it, April 18th, I believe. April 22nd.
Yeah,
April
something like that, yeah.
And within a month, on May 22nd, the United States Conference of Catholic Bishops sued the EEOC through the Becket Fund, asking the court to declare that these rules exceed the scope of authority of the EEOC because they go past what the Pregnant Worker Fairness Act said, because it's not supposed to cover abortion. And the other thing is the changes also weaken the religious liberty defenses to the claims and the free speech defenses and all these other things.
So we have to make this clear that even though this is a lawsuit from the United States Conference of Catholic Bishops, there are little faith-based organizations that should be concerned about this as well. So,
but USCCB covers every jurisdiction in the country,
well,
so they're a great client to do it.
Right. So that's what I'm saying is I don't want people to turn this off going, well, it's just a Catholic thing. No, because if they win, and I believe they will win on this, I think they're going to win. And so what's going to happen is there should be rejoicing across the faith-based board because this is going to protect all faith-based organizations from acting contrary.
And they sued in Louisiana, which is part of the Fifth Circuit Court. Texas, Louisiana.
Why didn't the Ninth Circuit, Jim? The Ninth Circuit is
the Ninth Circuit's actually not as bad as it was.
Well,
Trump appointed a lot of people.
He did.
It's about an equal 50-50 chance you'll get a good panel in the Ninth Circuit.
50-50 is much better than, what was it, 90-10 before?
Yeah.
Anyway.
So it's interesting. So just in May 22nd, the Conference of Catholic Bishops, which is all the bishops in the entire Catholic Church in the United States of America.
And the Catholic University of America, which is also part of this.
But it covers every state
right.
and every jurisdiction. And when you file a lawsuit on behalf of a small group of people, you never want to file a lawsuit on behalf of just one or two unless it's just their dispute. But if it's a kind of a general society dispute, you don't want your case to get mooted, which means it dies before it reaches its end because circumstances change, which took the claim away. Like your client had a heart attack and died.
Oh, right.
Or, whatever, right? So the client has to be alive and the damage has to still be happening. So by having the USCCB as the client making the claim, it covers every inch of the country. It was great. But Becket is a Catholic legal defense thing, so it makes sense they would work together.
But I did notice, because I read the footnotes in these things, and I did notice that they quoted the Alliance Defending Freedom in a couple of instances too, because again, we're talking about religious freedom, which encompasses everybody. So we're really glad that the USCCB did this.
And so what's going to happen in this lawsuit is the Becket Fund's website, and if you want to get into the nitty-gritty details of this, go to the Becket Law. Oh, shucks. What was the website? BecketLaw.org, I think. I think that was what it was.
And if you're watching on YouTube, check in the I'll put the links below.
And they have, you can actually look at the documents, but they're asking the Louisiana District Court, that's an Article 3 of the Constitution, lifetime appointed judge, or his magistrate, her magistrate, which is a 10-year appointed judge, not an Article 3 judge, to make a declaration at the end of this case that the EEOC does not have the authority to make these abortion rulings and water down the religious liberty and the free speech and the freedom of association protections and defenses against the claims, because they exceeded their power. Blah 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 blah.
So
blah.
may I?
It's the same thing I did in
I
'91.
was going to say. So may I take the ruling that's written there and insert it in your? Well, how do they do that at the legislature? I want those comments inserted as my own
journal,
right?
yes.
Because those are your own.
Yeah.
Yes.
So then I wanted to also bring up, because on May 21st this year, in the state of New York, the New York's highest court ruled in the Diocese of Albany's appeal of a New York High Court of a ruling that says the Diocese of Albany must buy health insurance that covers abortion. Now, remember the Little Sisters of the Poor? This has already been resolved 15 years ago. I don't remember how long ago it was.
It's been a while.
And the point is, pro-abortion activists never sleep. It's like our side would say, okay, well, that's been decided. We'll find something else to argue about. And so it's just really amazing. So the Albany Diocese argued that the regulatory action taken by the state to require religious organizations to provide and pay for coverage of abortion in their employee health plan is unconstitutional, involves government entanglement in the fundamental rights to exercise of your faith and your conscience. So it's, if you remember, Obamacare was Congress, required the Little Sisters of the Poor to pay for abortion. They aren't getting pregnant. They had to pay in their personal health insurance for abortion. And so this is the state of New York coming out in 2017 or whatever it was, after Little Sister of the Poor, and create the same on a state basis. So it has to be fought over in the state.
And may I just make my little snarky comment that one of us, and it's not me, is moving to New York.
Well, that's not going to be my state of residence.
I don't care.
My state of residence.
You always say,
the
I'm
free,
moving. That's why I'm moving.
The free state of Florida.
But you're going to be bilocating,
Yeah.
and so you have to deal with some crazy things.
I will be in upstate New York from 4th of July to a couple days after Christmas. And then when weather's getting bad after New Year's, I'll be in Florida until the 1st of July.
Okay, but before we run out of time, tell people what the USCB is asking for. So what do they want?
So in the Beckett Fund case, not this other New York case, they're asking that the court, so when you do a lawsuit, you ask the court for declarations and remedies. So the declarations are that this rulemaking exceeds the authority of the EEOC under the actual
check,
violates the religious freedom of people like USCCB.
Check.
Violates the free speech of people like the USCCB.
Check.
Violates the freedom of association of people like USCCB.
Check.
Therefore, issue a ruling by an order, like a temporary restraining order, preliminary injunction, order granting permanent injunction, that these rules cannot be enforced. What will happen? The EEOC will start again, and they'll find a tricky other way to get to the same end.
So it's not over. I mean, no matter what happens, because what they want is all of us to support abortion, to endorse abortion, to pay for abortion, to celebrate abortion. They don't care what our religious beliefs are.
It's a response to Dobbs.
And that's why we absolutely have to stay plugged in to what's happening in the news, no matter how ugly it seems and no matter how much we feel like we're not making a difference.
Or it's repetitive, it's redundant. It is, because they don't sleep on it.
It requires commitment. It requires prayer. It requires, determination and to just hang in there. So make sure you like this video, share this video, subscribe to our channel, hit that notification button so you know every time we upload a new video, and make sure you join us next week, because I'm going to hit Jim with some things that he hasn't seen in years just to get his reaction on camera. We'll see you all next week. Mahalo, everybody.
Aloha.